Your Honour, my name is Luke Lennon and I represent the accused, Mr. Darren Cedars. On his behalf, I wish to make submissions to the court that you exercise your judicial discretion in excluding evidence pursuant to your powers granted under Section 590AA, subsection 2 of the Queensland of the Criminal Code. I submit this application on the grounds that the oral testimonies given by my client whilst under police custody are inadmissible under the principles of fairness and public policy. Your Honour, it should be noted that my client is a 14-year-old of Indigenous descent and is therefore a special witness for the purposes of Section 21A of the Queensland Evidence Act. In addition to the statutory provisions afforded under Section 421 of the Police Powers and Responsibilities Act, it is also prudent to apply the high threshold for the admittance of evidence given by children applied by His Learned Justice Chesterman in the Queen and BBQ. Your Honour, the facts show that it is clear the police have recklessly disregarded these limitations in the pursuit of an admission of guilt, and also that at any time my client was not aware of the true implications of giving evidence. Before questioning a child, an officer is required to grant them access to a support person of their choice. On the facts, it is clear that my client did not choose Wendy to be his support person, as he never knew her, he did not know her, and at no time explicitly gave his consent to her assignment. It is also important to consider the dichotomy between my client's Indigenous heritage and Wendy as a middle-aged white woman, as it is unlikely that she would have been knowledgeable in any Indigenous communication techniques. This further draws attention to the breach of Section 420 of the PPRA, which requires police to notify legal aid upon taking custody of an Indigenous person. The negligent disregard for policies designed to protect special witnesses by the Crown have put my client at a disadvantage during questioning and made him vulnerable to potential cultural issues that could have affected the reliability of his answers. I direct your honour to recognise the existence of gratuitous concurrence, a trend amongst Indigenous peoples to answer direct questioning in a manner inconsistent with their own beliefs, often leading to a contravention of the facts. In this case, it is clear that my client viewed the police officers as authority figures. This was shown by both his continual failure to make eye contact as well as his relative silence, consisting of grunts and one-word answers. This leads to the direct possibility that my client was simply assenting to each proposition put forward by the officers when questioned due to his perception of an uneven power dynamic. Your Honour, this possibility calls into question each and every piece of oral evidence presented by the prosecution based on the ambitions of my client. Your Honour, it is in relation to the oral testimony given by my client in the back of the police car, it is necessary to consider both the obligations of the officers under Section 436 of the PPRA and at Section 130 of the Evidence Act. In applying this principle, I direct your honour to the test established in the Crown and Hasler, which discredits evidence that is overly prejudicial to the accused whilst being of small probative value. Your Honour, it is clear that the very possibility of my client being responsible for 8 previous offences of a similar nature is likely to severely affect the rational ability of a jury to prove that the main fact in issue, despite the evidence itself holding little value at all. This value is assigned not only because of the vulnerability of the witness, but also due to the legal principle that the accused cannot be convicted of an offence based on the indirect evidence of a previous crime. This is further bolstered at statute, as it is required for an officer of the Crown to electronically record any evidence if reasonably able for it to be admissible at court. Here is evidence that no such attempt was made to record my client's statement, even though it is reasonable to assume that the car and officers had access to recording equipment at the time. Although this could be attributed to genuine mistake, it further reduces the probative value of the evidence. Your Honour, having called into question the validity of the evidence submitted by the prosecution, it is pertinent to apply the 5-factor test set down by the Honourable Justices Stephen and Aitken in Bunning and Cross. Although there could be some indication of genuine mistake regarding the obtainment of my client's admission whilst in the police car, the admission of it as evidence would prejudice my client in a way that could only be described as unfair. Regarding the interview, the high number of breaches of my client's rights without any evidence of vitiating factors such as pressing circumstances or it being a serious charge demonstrate the police maintained either a calculated disregard for the policies in place to protect indigent vulnerable witnesses in order to obtain a guilty confession, or at the very least, neglectful indifference. It is for this reason that it is advisable that Your Honour exercise your judicial discretion to exclude any evidence in relation to my client's admissions of guilt whilst in police custody, on the grounds that its inclusion would be both unfair and contravene the general public interest. Thank you, Your Honour.